Court of Justice, via its president, Justice Adrian Saunders, in delivering its judgment on Wednesday, unanimously ruled that it has jurisdiction to hear the matter before it in the case of Irfan Ali and others versus Eslin David and others.
Since the Court of Appeal had no jurisdiction to hear the application brought by her, the finality clause in Article 177(2)(b, in 177(4), was inoperable, and under the laws of Guyana, this court had jurisdiction to hear and determine the application by Messrs. Ali and Jagdeo and to set aside the decision of the Court of Appeal.
The ruling of the court flies in the face of many activists, commentators, and the likes who had previously declared that the CCJ does not have jurisdiction to preside over the matter, using the finality clause of Article 177(4) of the Constitution of Guyana, as well as Section 4.3 of Act 16 of 2004, which enforced the CCJ as Guyana's final appellate court. The CCJ, in setting aside a ruling of the Court of Appeal, also spoke to the most recent report submitted by the Chief Election Officer, Keith Lowenfield, which had been submitted to the GECOM chair just a day after the ruling by the Court of Appeal. The court described the report as illicit and of no effect, citing that it invalidates the votes of over 115,000 Guyanese.
This court was also entitled and required to declare invalid the report issued by the CEO, which was based on the decision of the Court of Appeal.
The report, which had been submitted by the CEO, reflected a victory by the APNU AFC party ahead of their main political opposition, PPPC, based on only valid votes cast. The CCJ, in its ruling on Wednesday, declared that Article 163 of the Constitution of Guyana should be activated when addressing irregularities of the electoral process.
Say because of some fundamental irregularity, such as those alleged by Mr. Harmon, then that would be a matter that must be pursued through Article 163 after the elections have been concluded and the victors declared.
Justice Saunders was stern in his concern that the election process has gone on far too long and needs to end. He noted that it is now left to the Guyana Elections Commission to secure the report from the CEO that he was instructed on June 16 to deliver based on the tabulation of all votes from the recount exercise. An application for special leave was filed to the CCJ by Irfan Ali and Bharat Jagdeo, a day after the Court of Appeal had ruled in the matter brought before it by Eslin David through her attorney, Mayor Robertson, asking the court to interpret whether Article 177(4) of the Constitution of Guyana, where it says more votes are cast, means valid votes. The Court of Appeal had found that it has jurisdiction to hear the matter and proceeded to interpret more votes are cast actually means more valid votes, in alignment with Section 96 of the Representation of the People Act. The panel of the CCJ comprised the Honorable Justices Adrian Saunders, President of the CCJ, Witt, Rajnath Lee, Barrow, and Jamadar. Reporting for HGP Nightly News, Wendell Badrie.